everyone, and welcome to today's Privacy Espresso. I'm your host, Siyanna. I'm a data protection and IP lawyer from Timelex. And today I'm joined by Sam, who is a data privacy and security reporter at MLex. He has been covering this area since 2018, so just after the GDPR came into force. He's interested in new and upcoming EU laws such as the Digital Services Act and the AI Act. He's also moving to Brussels from London in a couple of weeks, so we'll get to know the new laws even better. So today with Sam, we are going to talk about the hot topic of international data transfers, and specifically the EU and US data privacy framework, as well as any upcoming challenges to the transatlantic data bridge. So Sam, can you tell us a little bit more about the EU-US data flows deal? We know that data transfers to the US have been an ongoing saga for several years. So what's the context and why is the new deal so important?
Yes. So I think it's kind of important to go back to the basics to start with, sort of consider why they are important. Why does it matter, data flows in general? Sort of people in this world, we kind of know the ins and outs of it and the real technicalities and all the paperwork and so on. But I think what we forget is that the transfers enable many, many, many things, just kind of the entire world, the tech world, digital world, and therefore the real world as well. So, for example, you think about how many cloud services are based in the US, big software technology companies, social media companies. It's the sort of thing where if it all stopped working, everyday people, non-privacy data protection people, they would notice, and lots of things would fall over. It's all enabled by data flows. The EU-US deal that's just quite recently come into force is the third version of that deal. We had Safe Harbor, then we had Privacy Shield, and now we have the Data Privacy Framework. The need for such a deal is a consequence of the EU's way of operating, the way of doing data protection law, where it wants EU citizens' data to be as well protected outside of the EU as it is in it. Otherwise, given the way technology and modern economies work, it would be kind of a pointless law if it only worked in the EU. And the reason that the EU is in a position to do that at all is because it was the first really to go with data protection law, and it has the sort of gold standard for data protection law. The most recent deal, as I said, came into force quite recently, and yeah, as I said, replaces the Privacy Shield, which was knocked down at the European Court of Justice in 2020.
Yeah, and we had the first two deals knocked down, right? So the first thing that people think is, okay, so Max Schrems is coming for this one as well. Do you think this is likely, and what would be kind of the consequences of that and the main issues?
Yes, I think it's inevitable. It's not likely. It's definitely going to happen, and it will almost certainly be called Schrems 3. So Max Schrems, I don't think anyone watching this won't know him, but he is an Austrian privacy campaigner. And he started all this, I think, when he was a student. Sort of incredibly effective and influential given how young he was when he started, and I don't think was even a qualified lawyer. He is now. But yeah, he challenged the first two, Schrems 1 and then Schrems 2. And yeah, a challenge of this one is really very, very likely. And again, sort of setting the scene before I get into the detail of the challenges, lots of lawyers that I spoke to, so I myself am not a lawyer, but I speak to a lot of lawyers, and they have become quite sort of jaded with this, I think. So when the third deal was passed, they obviously said, it's good news, it will make things easier. But they also, a lot of them sort of were feeling hesitant and cautious. They've sort of learned the hard way that these deals get knocked down, and they advise companies that, yes, this is a good thing and this will be a new way of transferring data, but don't imagine it's going to last forever, or at the very least, don't imagine it's going to go unchallenged. And that's kind of, yeah, people are getting world weary of it. So at the moment, Schrems has not yet challenged this deal. Someone else has, a French lawmaker called Philippe Latombe. He's challenged it in a sort of personal capacity, not as a member of the French. He's not as a French parliamentarian. He has done that at the EU General Court. So he's actually sought to have the deal annulled. Most people think this isn't going to work, mostly because there are quite strict admissibility requirements for bringing such a deal as an individual person or an individual company. It's quite hard to apply to annul something like this. There are admissibility requirements and so on. Two NGOs tried the same thing. They tried the same legal route to challenge Privacy Shield, but they were ruled inadmissible. That was before Schrems. Latombe is trying some new sort of legal arguments to say he's been directly affected by it and he's lost rights and that kind of thing. But a lot of people still think it's not likely to succeed. Schrems himself, he said that he thinks the best route to go is what he's done in the past, basically seek to challenge a company using the deal in a national court. It's an EU matter. The national court will inevitably refer it to the European Court of Justice, and we have a repeat of the first two. When it is challenged, sort of on the substance, there are two main issues. So the first is this kind of these concepts of necessity and proportionality, and the second is access to redress, being able to challenge in a court sort of US surveillance data collection. It's sort of worth saying at the start that Bruno Ceccarelli, who is the man in charge of data flows for the EU at the European Commission, he has said, I think he said it at a conference, that this deal has kind of inherently a better chance of surviving than the previous ones, because the European Court of Justice in the Schrems II decision sort of really laid out in quite precise detail the problems it had, why it struck it down. So that almost gives like a playbook to the negotiators for how to address that. So that Ceccarelli says has made their life easier. So on these two issues, the first one, necessity and proportionality, that was seen when that was included by the US kind of in the deal. That was seen as a really big thing because they are kind of EU gold standard legal concepts, and it sort of was considered a very big deal that was included. Schrems, for his part, and it's important what he thinks because he's probably really on that challenges it. He says that just because the US has agreed to use those terms doesn't necessarily mean all that much, because they don't mean the same thing to the US as they do to the EU, and I don't think sort of a really, really strictly defined sort of definition has been agreed. So that'll be one thing. The second thing is this access to redress. So under the previous system, it was an ombudsman. Under this system, it's a data protection review court. The question is, just because they called it a court, is it actually a court? And some people on the EU side, including Schrems, say basically no, it's not, because it's not sufficiently independent of the US executive, because it was made by an executive order, and the issue is to do with people's admissibility to US courts. So Article 3 standing under the US Constitution basically means if you're going to bring a lawsuit, I'm going to sort of quote the legalese here, it has to be based on an actual or imminent alleged injury that is concrete and particularized. And you can't do that if it's about spying, surveillance, because that's all secret. That's why it has to be a different kind of court. And you can see, the US is in a bind there. They're not going to change their constitution because Max Schrems wants them to. And people can't get standing for spying cases. So that's why they're having to make this court. The big question is, will the European Court of Justice consider that to be a proper court, and therefore is that proper legal redress? Schrems says no. We'll see. We'll see what the court says. One of the other issues in relation to the court is the sort of the information that it will give to people when they make a claim. It will essentially say something along the lines of your data may or may not have been processed in the course of spying activities by US surveillance authorities. So, that's not how it would work in a regular court. You imagine you'd get a lot more detail than that. So sort of the other side, people on the US side, sort of senior people within the relevant government departments, they say they're confident because, a lot of legal scholarship has gone into this. The court has the force of law. Executive orders have the force of law. They say the court is genuinely independent. For me, it's impossible to call. I think, even great, very intelligent, very well-read legal scholars don't know, so it's too hard to say. Those are the main issues in a challenge, which is almost inevitable and may come before the end of this year.
Okay, fascinating. So let's say that in the end, Schrems 3 has kind of the same outcome and the deal gets overturned again. What do you think will be the alternatives afterwards for EU-US transfers?
So there are a few. Sort of, I'd say there's three main ones that I see. Two of them are quite unpopular. So the first is just local storage in the EU, just store all your data in the EU. That's pretty unpopular. It costs a lot. It's inefficient. It doesn't really sort of represent or go along with how the modern internet and kind of communications networks and companies work these days. So that's basically out. Sticking only with standard contractual clauses, which is the kind of the main alternative to an adequacy finding, is, well, that would be what would happen, but it's pretty unpopular. There are a lot of work, and every time a a finding like this happens, there are more and more requirements for those clauses and lots of paperwork for lawyers to do. And the other thing is it kind of leaves companies a bit vulnerable. If that's the only option, what if SCCs are considered to be unlawful? Where do they go then? The bigger, sort of more interesting alternative is a move away from this kind of unilateral EU adequacy model, where the EU says, you're good, you're not good. What a lot of people want is a kind of multilateral model. And we're seeing a few things where that's starting to happen. So even in this deal, in the EU-US data privacy framework, the US has included this clause where states have to qualify to be designated as having access to the court and so on. And obviously the EU has access to that. So does the UK, just quite recently. But it's just a kind of sign that the US is trying to shift the balance of power a little bit. The second thing, sort of example of this, is there's an OECD initiative on kind of shared principles for government access to private data. That's a pushback against data localization. And there's also the Global Cross-Border Privacy Rules System, which is kind of a similar thing. This, in general, is people wanting to move away from this unilateral model towards multilateral models. And it's in its early days, but there are lots of proponents of this. So if another one is knocked down, another Schrems 3 is knocked down, I think that's the direction we'll go in.
Okay, interesting. I think we're running out of time, so thank you so much, Sam. This has been very informative. It's been a really, really good overview. So yeah, thanks a lot. And
thank you.
Then yeah, we see the others in the next Privacy Espresso.
Cheers.
Bye-bye.